here. We don't have a quorum just yet, so we'll have to give it a few minutes and see if we get some other board members in attendance, because otherwise there's really no point in hearing any business. So thank you for your patience, and thanks for coming today.
We just lost internet. Pardon, one moment.
And let me just interrupt briefly. Did you want to move the elections to the end of the agenda?
Oh, do we want to?
Or prefer to begin with them?
Yeah, let's move. Probably as big a crowd as we've ever had, so let's not make them sit through our housekeeping matters. We'll move those to the end. Do I need to make a motion to move those to the end? I'd like to move that we move today's board elections to the end of today's hearing to let all these folks get back to their lives. Whitney, second. Can I see a show of hands? Super. Okay. We'll be moving the elections to the end. If you guys want to stay, it'll be riveting.
Good afternoon. The Metropolitan Short-Term Rental Board of Appeals is now in session for the regularly scheduled meeting of August the 30th, 2023. I am Short-Term Rental Chief Bonnell McBroom, and I will be presenting the cases for the board for review at today's public hearing. At this time, I would ask everyone to either turn off their cell phones or put them on silent as to not disrupt today's meeting. The procedure will be for the staff to introduce the case record. At the conclusion of our presentation, the appellant will present their case to the board along with any person in support. If there is opposition to the case, the board will then hear from those parties. After opposition has presented their testimony, the appellant will have a period for rebuttal. The board in their rules provide for cases without opposition, 5 minutes total for the appellant, including members of the public speaking in support of the appeal, to present their case and supporting comments. For cases that have opposition, the rules provide the appellant, including members of the public speaking in support of the appeal, 10 minutes total for their presentation and rebuttal of the opposition's presentation. For members of the public speaking in opposition, 10 minutes is provided. This is 10 minutes total for all speakers combined and not 10 minutes for each speaker. For members of the public that want to submit comments to be entered into the record prior to the meeting that are either in support of or in opposition to an appeal, the comments must be submitted to the board no later than 5 days prior to the public hearing. Documentation supporters or opponents wish to provide to the board after the deadline can be presented to the board members by providing 8 copies of at the public hearing. However, the board may elect to defer cases in order to review any materials received after the deadline. The Metro Code requires that these proceedings be taped. Therefore, it is imperative that anyone addressing the board come forward, speak into the microphone, identify yourself, and then make your presentation. It should be noted, if it is found that anyone has presented false or misleading testimony to the board that would have affected the board's decision, any approval may be revoked at a later date by means of show cause hearing. The board will go through the cases set for the public hearing today. After both sides of the case presentations are made, the board will discuss and vote on the case. The board is vested with the power to act on these cases before us today under the provisions as outlined in Section 6.28.035 of the Metropolitan Code. The code requires 4 members of the 7-member board be present to constitute a quorum. The board rules require a majority vote in the affirmative of the members present to grant the appellant's application. In the event that a majority vote is not achieved, the case will remain on the board's agenda for the next regularly scheduled public hearing. Applications that fail to receive a majority affirmative vote at the next regularly scheduled public hearing shall be deemed denied by operation of law. Any aggrieved party may, within 60 days of the entry of an order, appeal a finding of the board under common law writ of certiorari in accordance with Tennessee Code Annotated 27-9-101. Chancery Court within that same day 60 period. After that time has elapsed, the board's decision becomes final and no further action can be taken. If you're an appellant and your case is granted, it will be necessary for you to obtain the permit for which you have applied. It should be noted that the permit must be obtained within 2 years for the board approval to remain valid. I submit that all cases have been filed in proper order and the appellants have been notified by certified mail as required by the code. All affected property owners have been notified by the legal notification sign requirements and the legal notification sign requirements have been met as required by the code. Chairman Caputo, before we move on to the cases to be heard, we would like to take this opportunity to recognize any elected officials who are in attendance. Seeing none, there was one email that was forwarded from Councilmember Berkeley Allen that from a constituent in opposition. It was an opposition email for the appeal case on 2023-63 at 1015 Villa Place, a copy of which each member was given. Absent any other announcement, Chairman Caputo, we are ready to proceed with the cases to be heard.
Terrific.
The first case to be heard is case 2023-63. Is the appellant present? Is there opposition? It's 1015 Villa Place. In that case, each side will be given 10 minutes. The appellant must remember that they need to reserve any time out of the 10 minutes that they choose to use for rebuttal for the after the opposition presents their case.
I think extend for both, right? Okay. Before, Mac, before we get going, let's make sure that the opposition can work together to meet that 10-minute limit. And if you don't think it's possible, any extra time that we would be required to allot to you, we're going to also be required to provide to the appellant. So let's get that dealt with before we get started. Everybody can keep it to 10 minutes. 10 minutes total. Super. I love cooperation. That's excellent. Great. Okay. So why don't we have the appellant come forward and take a seat here, and we're going to hear from Metro first.
Case 2023-63, 1015 Villa Place, Ashley Clemens and Representative Joseph Shields. Permit was denied for advertising and operating before a short-term rental permit was obtained. This is an R6A zone, which allows only for owner-occupied permits. This case is governed by BL 2020-187. Therefore, the decision of the board is whether or not the zoning administrator erred in the denial of the permit. On May 5th of 2023, a VRBO website advertisement was posted. The advertisement was hosted by Joe. The host profile picture was of Mr. Shields. May 19th of 2023, the property was acquired by Ashley Christine Clemens and Joseph John Shields IV. On June 1st of 2023, Ashley Christine acquired the property from Ashley Christine Clemens and Joseph John Shields IV by quitclaim deed. On June the 9th, 2023, Inspector Robert Osborne processed the short-term rental permit application for the property, and Mr. Osborne found that there were 2 document stays in May of 2023 on the website advertisement. This is the same VRBO advertisement noted above, which posted on May 5th of 2023, hosted by Joe, featuring the photo of Mr. Shields. On June 9th of 2023, Inspector Robert Osborne denied the permit application based upon the operation of the short-term rental property prior to obtaining the permit. June 22nd of 2023, I conducted a search of social media accounts, which is standard procedure for our investigation. And I found Ms. Clemens' Twitter account. On the homepage of Ashley Clemens, with her photo and 40 Oz steak with Mr. Shields' photo were listed under the caption "Relevant People." When I conducted a search of 40-odd Steak, I found a private Instagram account with the host photo of Mr. Shields, which appeared to be the same photo that was on the VRBO website advertisement host page on the advertisement for 1015 Villa Place. The 40-odd Steak Instagram account page contained the following description: owner and designer at Seek Stays. Book your next stay. And then it's a listing of properties that were on that website. SeekStays.com. I searched Seek Stays on the Tennessee Secretary of State website and found it listed as Seek Stays LLC, with the principal office and mailing address listed as 1205 Tremont Avenue, Nashville, Tennessee 37212. I accessed the SeekStays.com website and found that it is a private website for short-term rental properties below the Muse at 65 Lindsley Avenue, Nashville, Tennessee 37210. Property number 1, 65 Lindsley Avenue, number 304, owned by Timothy Antos. And permit number is listed along with the type, which is a not owner occupied. 65 Lindsley Avenue, number 309, which is owned by Joseph John Shields IV. Permit number listed, also not owner occupied. 65 Lindsley Avenue, number 510, owned by Joseph John Shields IV. Permit number listed and also not owner occupied. 1035B Scoville Street, owned by Joseph John Shields IV, with permit number listed, and it's type 2, which is an older, not owner-occupied permit. 1035A Scoville Street, Timothy Antos is the owner, permit number listed, also not owner-occupied. And 1205 Tremont Street, owned by Joseph John Shields IV, permit number listed, and it is type 1, an owner-occupied permit. Note the host photo on the Airbnb ad for 1205 Tremont Street is identical to the host photo on the VRBO ad for 1015 Villa Place. Mr. Shields owns or manages each of these properties, and each property has a short-term rental property permit. I can only conclude from this that Mr. Shields is well aware of the Metro Nashville short-term rental property ordinance. July the 6th of 2023, the appellant, Ms. Clement, sent the following email to the short-term rental property inspector, David Frabit. Hi, David. It's nice to meet you. I really appreciate you taking the time to take a second look at this. I want to clarify that I closed on the property on May 22nd, 2023, and I have not managed, operated, or advertised the property since purchasing, nor did I hire anyone to do so. Joseph Shields also has not managed, operated, or advertised the property since that purchase. As far as I understand, it appears the previous owners had a listing up, but as far as we know, nobody has stayed at the property prior to our closing. Joseph Shields and I do not know the previous owners personally and did not manage the property for them previously. I have attached 2 documents clarifying the above. If there's anything else that I can do to help clarify, please let me know. Thank you again for your help. My best, Ashley. This seems to be contradicted by the VRBO website advertisement for 1015 Villa Place in your case summary. The 2 documents mentioned in the email were each titled Declaration of Non-Operation, Disclaimer of Liability, and Release, and are included in the board's case summary, along with the email from the appellant. On July the 19th of 2023, the Short-Term Rental Board Appeal was filed. There was 1 short-term rental property complaint for the property in the Nashville hub, but it was from the date of February 21st, 2023, and concerned the previous owner, 2 owners prior. There are no complaints on the short-term rental hotline property. There were 3 letters in opposition, of which hard copies were provided to each member of the board.
Thanks, Mr. McBroom. Is that the whole of it? And if so, I will ask if anyone would like to ask any questions of Metro before we hear from the appellant. Oh, sorry. Any questions? I do have one. If you could just clarify for me, and I'm sure for other curious folks, there is an asterisk for owner-occupied, which we understand, and then not owner-occupied, old type versus not owner-occupied, which I imagine is the current type. Do you happen to know what the distinction is between the old type and the current type?
Yes, at one time there were three types. There was the owner-occupied, there was a non-owner-occupied, and then a multifamily. Actually, it currently is a multifamily that is issued, but in the ordinance, it's still referred to as a not owner-occupied.
Okay.
That type 2, though, has not been available now for some 2 to 3 years.
Understood. Okay, super. And then the last question I have is, just because I don't have the docket in front of me, this is under 2020-187. So the discretion left to the board is only, do we believe that the zoning administrator erred? Am I correct in that?
That is correct.
Okay, great. Anyone else have any questions? Terrific. Okay, we're going to hear from the appellant, and you heard the instructions that you both need to give if you're both speaking, we need both of your names, your addresses for the record, and we are going to limit your time to 10 minutes total. So 10 minutes total, meaning if you want to rebut anything that is said by the opposition, those folks who've come to speak today about your case, you're going to save some of that time because it's 10 minutes total. We good? Super. Okay. Please take it away. Tell us about your situation.
Is it green light is on?
You want to press where it says push?
Hello?
It's the green. Okay.
Okay. Sorry. Yeah, my name is Joe Shields of 1205 Tremont Avenue, Nashville, Tennessee, 37212.
And hi, my name is Ashley Clemens of 1015 Villa Place, Nashville, Tennessee, 37212.
Yeah, and just to start, I just want to re-summarize the case on our side. While Ashley was in the process of finishing her owner-occupied permit application, an active verbo listing was discovered for 1015 Villa Place. The listing belonged to myself, and the listing had 2 recorded reviews. The reviews were supposed stays on May 1st and May 9th of 2023. And to summarize our appeal, the reviews on that listing aren't actual stays at the property. The recorded reviews from May 1st, 2023 and May 9th, 2023 are from days when neither Ashley or I own the property at 1015 Villa Place. Ashley and I closed on 1015 Villa Place on May 22nd, 2023. The recorded review from May 9th, 2023 is actually a review left by Ashley Clemens herself. And the recorded review from May 1st is a review left by Ashley Clemens' brother, Kyle Clemens. And no actual operation of a short-term rental ever occurred at the property. No guest ever occupied the property because we didn't own the property. We didn't have access to the property during the supposed recorded stays on May 1st and May 9th of 2023. And the intention of creating the listing in the first place was to prepare it as essentially like a template so Ashley could use it when she eventually received a permit and created her own listing. I also had set it up, wanting to see how photos looked and test some automated messaging software I created. And this particular listing was never actually intended to go live or publicly listed on or advertised on Verbo. I'm not sure if you guys have the provided doc that we submitted, but in that doc we attached screenshots and emails to kind of substantiate the claims here. And I can kind of go through those. I'm not sure if you guys have them, but there's a bunch of screenshots and emails to kind of go through that. But yeah, just to go into that, some of the documentation, it's kind of labeled exhibit by exhibit, and Exhibit 2 and 3 in that document is a screenshot of the Verbo inbox page, and those are screenshots from Ashley Clemens's and her brother's, Kyle Clemens's, personal accounts on Verbo, and this is kind of showcasing that these are essentially like fake reviews that took place during a period of time where the house was vacant, non-operational, and myself and Ashley did not have access or even own the property. And these screenshots are only attainable because they were provided by Ashley and her brother. Exhibit 4 as a screenshot of the reviews page for 1015 Villa Place, and this section, or in the section date stayed, it shows that the reviews left on the listing were from dates when Ashley Clemens and I did not own or have access to the property, May 1st and May 9th. We bought the home on May 22nd. Skipping ahead a little bit to Exhibit 6 is a screenshot of the inbox page for the Verbo listing. The screenshot was taken Sunday, August 13th. It shows that there have been no other past, present, or future reservations. This is kind of a comprehensive list of all the incoming inquiries, bookings, messages left at the property. And I have a additional screenshot. I've never submitted it, have it in a doc here, but it's an additional screenshot from August 30th showing that there's been no other inquiries or bookings that have been made at the present time. And then skipping ahead a little bit more, Exhibit 9A and 9B is an email from Verbo support, and this is kind of going into the aspect of we never intentionally advertised the listing. We never intended for the home to be rented right away at all anyways, but there's an email from Verbo support confirming a technical error / like issue causing the automatic reactivation of the Verbo listing. The email explicitly states that I did not activate the listing and clarifies that the reactivation was a result of a technical issue originating from Verbo. And then Exhibits 10, 11, and 12, these are emails just trying to substantiate the claim that there was no actual operation or people staying at the property. These are emails between Jeff Cernak, our real estate agent, and I confirming a walkthrough at the property, 1015 Villa Place, on May 1st at 4 p.m. Jeff, Dave Haverkamp, the seller and owner, Ashley Clemens, and I met at 1015 Villa Place to review inspection and report repairs. Exhibit 11 and 12 are emails between Jeff Cernak, our real estate agent, and I confirming a meeting with Michael Ward, who's an architect at the property 1015 Villa Place on May 9th at 3:30 p.m. Michael Ward and I met at 1015 Villa Place to review plans to build a dadu and pool in the backyard. And starting the dadu build process was a conditional on our closing. And then kind of just to wrap it up a little bit, to explain it, and we received some of the like opposing letters and stuff, and I think there's kind of a general misunderstanding of like where our intentions are with the property, but I just wanted to kind of clarify that a little bit. So we purchased this property with the intention of making it our future home. Currently, Ashley lives at 1015 Villa Place, and it's her primary residence, and I plan to eventually move in with her, but we're in the process of doing a bunch of renovations and construction, and we both really love the house. It's super unique. It's got a lot of character, a lot of history. It's a very old house, but it has a lot of charm, and it's in our favorite neighborhood in Nashville, Edge Hill. I've been a Edge Hill resident for almost 6 years, since 2018. It's close to a bunch of wellness and fitness centers that Ashley works with over on Music Row. We're pouring our kind of hearts into the property. We're putting a ton of money into it. The initial intention of getting a short-term rental permit was to cover costs of the mortgage and some of the extensive renovation projects that we had planned. We just redid like the landscaping in the front yard, put a new irrigation system, a lighting system, a host of other updates. We're redoing the front porch, installing a new roof, remodeling the kitchen, and then we're eventually planning to build a dadu and a pool in the backyard, which will the dadu will eventually be the space that we want to rent out in the long term. So considering all the unique circumstances surrounding the case, we kind of firmly believe that the documentation affirms that a lot of the or the assumption that we actually operated is kind of false, because we've never actually had anybody stay at the property. I guess it's kind of a reinterpretation of what the term operation means, but we never had anybody stay at the property. We never intentionally advertised the listing. The home's been kind of in rehab mode a little bit. We're doing a bunch of rooms. There's some aspects of the home that are finished and complete, but we never intended to initially rent it when we first purchased it. So, yeah, I think that's everything.
Okay, Mr. Shields,
Yeah.
thank you so much for that information. Just for your information, you'll have 2 minutes left to speak after we've heard from your neighbors. Before we hear from the neighbors, did anyone want to ask any questions of Ms. Clemens or Mr. Shields? So I do have one quick one, which is that, so this is number 7 property for you, Mr. Shields, number 7 short-term rental?
Yeah.
So, terrific. So with that much experience, you're well aware of the rules surrounding short-term rentals, that to advertise, even accidentally advertise, a short-term rental violates the short-term rental rules.
Yes.
And as someone who owns 7 short-term rentals, or 6 others, or 7 others, that's probably something you're well aware of.
Yeah, I'm aware. Yes.
When did you buy your first short-term rental, and when did you get your first permit?
In 2018.
2018. So
Yeah.
quite a long history you've had.
Yes, I have. And I just want to point out that we did receive, we never intentionally
We got
advertise
that.
it.
Yeah,
Yeah.
we heard you. And I see the documentation that you provided as well on that
Yes.
topic.
Yeah.
Yeah. Anyone else? Okay. Folks, I'm going to have you step aside just to give some room for your neighbors who might want to come. Even if they're going to limit the number of people who speak, I want to give them the space to come forward.
I think a bunch of us are going to speak, but each of us very, very briefly.
Okay. So I'm just going to reiterate for you folks that we need to be very respectful of the time. So it's going to be 10 minutes total. So also anyone who speaks needs to give their name and their address. And also, just because we've done this a few times, let me just give you a little guidance that we want to keep your comments to this issue at hand. And I think we've seen the issues that you've all brought up, some of your other neighbors have brought up with their letters in opposition. So the issues that we've seen brought forward were, advertising outside of what's permitted by the rules, and the issue of whether or not this is truly an owner-occupied property. So let's not go too far afield about things that aren't, in Mr. Shields or Ms. Clemens' purview, like whether or not you think there should be short-term rentals in general. It's really not something we can decide here today. So let's just try to stay on point as much as possible. Okay? Sounds great. Okay.
My name is Joyce Searcy, and I live at 1029 Villa, so for 22 years. And Villa Place is a real neighborhood where we all know and care for one another. But what we also know is nobody's occupying 1015 Villa Place. If that were the case, we have a neighborhood organization where we would have welcomed them to the neighborhood to join in the activities. And so we're sure that it's not possible to award an owner-occupied permit to an owner that does not live on the premises. So we ask that you deny dispensation to apply for a short-term rental before the waiting period, because nobody lives there. And my husband, Walter Searcy, has written a letter. I reside at 1029 Villa Place, and I'm strongly opposed to another owner unoccupied short-term rental permit being issued in our block. Codes does not allow such, and I oppose an exception being made herein.
Thank you, Ms. Searcy.
My name is Allison Schachter, and
Ma'am, could you, thank you so much.
My name is Allison Schachter, and I reside at 1022 Villa Place. I would like to add that I was going to say that I have never seen the place occupied. I walk past it regularly. I regularly see packages sit for days. Also, that the property at 1205 Tremont, which is owned by Mr. Shields, has at least 5 complaints online for being owner unoccupied, and that I'm concerned at this idea of fake reviews being posted, which also really raises questions about honesty. I was in communication with our council member, Freddie O'Connell, who meant to write in, and he texted me today, and this is what he texted me. Most of the conversations we have had in Edge Hill and Nashville neighborhoods over the past 8 years have involved short-term rentals where the owner is not an actual resident or owner of the actual home. I believe this board should generally oppose permits where an owner-occupied rental will never be legitimately occupied by the owner, and I certainly have questions about one person who already has an owner-occupied permit getting another with someone else. That's my addition, that last sentence. I certainly have questions.
Thank you so much, ma'am.
My name is Alicia Brooks. I'm a resident of 1013 Villa Place. I'm a Nashville native, but I've lived at 1013 since 2016. And I do have photos. I do apologize. I did not know I needed to submit those, but I'm their next door neighbor. So you walk out of my front door and you can see everything going on in their house, you know, relatively speaking. I have photos that show that no one has lived there since the Siltras moved out. I have photos where it's been gutted, where still no one's lived there. An old owner before these two had showed me the property, and to this day, I can still see that nobody has lived there. They've been making renovations, and workers have been there, but there's nobody that resides at this property.
Thank you.
Hi, can you all hear me okay?
Sure can.
My name is Jason Laskew. I live at 1016 Villa Place, which is across the street from the house in question. I'm here to oppose the short-term rental. I'm also here to present my observations as this house is not owner-occupied. I have seen several packages sit on the porch for days at a time, and I have photos of that that I could submit. Also, my son does a lot of late soccer practices. We get home late, and I continually see the house dark, unoccupied, except for one light in the background. It is my hope that you all deny this short-term rental, because I do not believe there is someone living there at the moment. Thank you.
Hi, I'm Elisa Beek. I live at 1011 Villa Place, which is, you have 1015, you have Alicia and the units here, and we're the next house over. Our second floor looks over every single window of their house. My husband and I also, so we can see that nobody lives there. My husband and I work from home. We are very active in the neighborhood and in our yard and front yard with our children, taking walks. Nobody lives there. It's just, it's not owner occupied. So I'm here to be a witness for that.
Thank you, ma'am.
Hello, I'm John Moore. I'm at 1010 Villa Place. I'm across the street. I concur with my neighbors. No one is there, but there is construction work and lots of crews going in, doing a lot of work around there. We don't see anything there. And I believe the ordinance needs to stand the way it is. There's a reason why there is an ordinance there. And we all must follow by the rules. I don't believe there should be a remote, whatever you call it, short-term rental operation from a different location. You should be on the premises. Thank you.
Thank you, sir.
Hi, my name is Ben Tran. I live at 1022 Villa Place. I work at Vanderbilt, and I walk to and from my office every day. I walk my child to the bus stop, and I can tell that no one lives there since the Zilsters have sold the house in 2020. And I also do have a question about the false claims, about the false advertisements, and then this rush to get a permit before the DADU that Mr. Shields just said that he was going to use to rent out, and that DADU has not been built, yet the permit is being asked for. And I do have a question about that and why the order of things that are happening. It seems premature to me, and I hope that you deny this short-term rental.
I'm sorry, would you remind me of your name? I think you said it, but I missed it.
Ben Tran.
Mr. Tran, thank you so much for your time. And thank you all so much for your discipline, because you had 4 minutes left. So if there's anything else that you want to add, you have 4 minutes and 8 seconds. No? And quickly, does anyone on the board have questions for any of the neighbors, any of the opponents? Okay. Great, thanks again. Folks, you have 2 minutes to rebut anything that you heard. So hold on, let me just set my timer back. The floor is yours.
Thank everybody for coming in to take time out of their day to say what they had to say about the case, and we share the same sentiment about short-term rentals and making sure that they're abiding by the rules and laws. But as you heard, there's no none of the opposition stated anything about the property being operating as a short-term rental. It was mostly about whether or not the property is owner-occupied, and that's not what we're here for, but I do have a document that I'm happy to provide. It has a ton of information about Ashley. It has security camera footage from the property of her coming and going every single day. Myself and Ashley are in the neighborhood every single day. I have security camera footage of my property, of me coming and going from my property in Nashville every single day. We have, various Postmates receipts of food being delivered to the property throughout the day that I can provide. I would just say that most of the opposition is in disagreement of whether or not somebody actually lives at the property, but all of Ashley's stuff is in the property, her belongings, her furniture. We actually bought the property fully furnished and then sold everything because we brought in all of Ashley's furniture and everything like that. So, if that comes to be as a point of opposition, we have a ton of information and documentation to prove otherwise. We have.
Okay, Mr. Shields,
okay.
Thank you very much. We appreciate all of your time and all of the information. So we're going to consider this, but unless anyone has any questions for Mr. Shields or Ms. Clemens, we're going to consider the public hearing closed. That means we won't hear from, sorry, let me turn this timer off. We won't hear from anyone unless we reopen the public hearing. I did just see one of the folks who spoke in opposition put a hand up. They did have 2 minutes left, but I don't think we do this back and forth. Like, it's not a counterpoint kind of thing. So I'm dating myself with that old SNL reference there, but so sorry that we consider the public hearing closed for now. Unless someone on the board reopens it to ask a question, we're just going to discuss this amongst ourselves now. We've got the public hearing closed, okay? Thanks so much.
I'll just add that if you felt that there was additional time given to one side, you could give additional time to the other.
Well, additional time wasn't given, but they didn't take all their time. What do you think about that?
For the group in opposition.
So the opposition only used 8 minutes? 6 minutes, sorry, you're 100% right. They used 6 minutes. They have 4 minutes left, but we are not in the habit of doing
That's generally
point
not the
counterpoint.
procedure. Okay. The board has the discretion to hear them if you wish to.
Okay.
Yeah.
I think we're good. I think we heard a lot. Now Mac wants the floor. What's up?
I would just like to clarify that the law that governs this, 2020-187, reads, no person or entity shall operate a short-term rental property or advertise a residential property for use as an STRP without the owner of the property first having obtained a short-term rental permit issued by the Department of Codes Administration in accordance with the provisions of this chapter. In addition, the rules for leaving a review on VRBO are on your screen. You cannot leave a review unless you have stayed, at which point you will be sent an email if you qualify, and you have to book through VRBO and also pay through that. So I bring into question the reviews.
All right. Thank you, Mr. McBroom. I appreciate that. Yes, we have closed the public hearing. So now, who would like to begin?
Well, potentially much to the chagrin of all those folks who took time to come and express their opposition, and our respect for you guys taking your time to come.
I don't think they can hear you. There we go.
I'm not on. Sorry. I was saying potentially much to the chagrin of all the folks who came to express their opposition, which you do appreciate. I don't think the issue before us is whether or not this is an owner-occupied property. I think the in question before us is entirely different, which is whether or not there was advertising or operation prior to. So I wanted to make that clear before we got too far into the discussion, that while we appreciate all the points of view and all of the sentiment and the unity of the neighborhood, in your statements, that's not, unfortunately, the issue. That we're a board of limited jurisdiction, and we sort of have to focus on the issues that are put before us to decide. And as to this case, it's whether or not there was ownership or whether or not there was advertising or operation before a permit was validly issued.
I'm afraid I'm going to jump in, actually, just looking at the under 628.035, right? You have jurisdiction to uphold, reverse, or modify in whole or in part the zoning administrator's decision. And in terms of that modification, if there are other grounds, you can state other grounds. And I'm just going to make that clarification.
Yeah.
Okay.
I don't think all of the ordinances have that, but this one does. So, yeah, I think that was, even though that wasn't the initial cause of the denial, that it is in contrast to what the ordinance permits. So
I stand partially corrected then.
And he's a lawyer, and he actually admitted that.
Yes, I will fall on my sword on the occasion.
So for me, even setting aside the owner-occupied debate, Mr. Shields owns and operates numerous VRBOs and has since 2018. I don't think he was somebody that was necessarily trying to figure out the VRBO software. It wasn't a new platform. I don't know why we're putting ads up even before, and y'all correct me if I'm wrong on this, but even before the property was officially purchased.
Right. That was my concern.
So if you're putting an ad up even before the property is officially purchased, we haven't even gotten to the permitting stage at that point. So I remove the owner-occupied debate from this in my mind, because I think there is some back and forth there that we could potentially have on that issue. But ultimately, if our threshold here is whether or not the zoning administrator erred, I don't see that there's an error, because it's very cut and dry to me that no matter what the intentions were, the advertisements were up.
Yep.
And the statute does not allow for intentions. It just allows for whether or not the advertisements existed.
Yep. And the reviews were the reviews were acknowledged as reviews that were left, and we just heard the rules for VRBO. So the evidence in my mind weighs more heavily in favor of something happening that should not have happened, no matter what their intentions were.
Yeah, and the stays, for me, the stays or the reviews, even taking that out of the equation, the advertisement was there.
Right. And that's right.
Yeah, I have a few concerns as well. Considering the timing, the permit before it was done, also if it's a different structure that is actually intended to become the actual rental. I know that there's fire inspections and floor plans and all of that are highly relevant. And then whether the two reviews, documented stays were fake or not, to kind of start building. That first review I know is difficult to get. You want it to be good. It's also kind of having your cake and eating it too. So I'm having a little bit of difficulty getting over some of those issues.
Okay. Is anyone ready to make a motion?
I move that we hold that the zoning administrator did not err and deny relief.
I second. Can I see a show of hands? Okay. Very good. Ms. Clemens and Mr. Shields, thank you so much for coming in today. We are not going to offer any relief in this case, but we greatly appreciate your time and all the information you shared. Same for the neighbors. Thank you so much for coming in. We appreciate your time and hope you have a great day. Good luck to all of you.
Thank you all.
Okay. Next case. And there was another one on the docket, right, that was withdrawn? Am I correct on that?
Yes, the next case that was listed on the docket was 2023-64 for 907 Villa Place, which was withdrawn.
Great.
And the last case on the docket is case STR 2023-65. Is the appellant present?
Yep.
Is there opposition in present? Seeing so, each side will have 10 minutes. The appellant will have 10 minutes total, including time that will need to be reserved for any rebuttal after the opposition has presented their side. The address is 2101 June Drive. The appellant is Michael Serpas, and he is represented by Mr. Klein. The owner-occupied permit was revoked. The basis of that is that it is not the owner's principal residence. This is an RS-10 district, which only allows for owner-occupied permits. Again, we were governed by BL 2020-187, and the decision of the board is whether or not the zoning administrator erred in the revocation of the permit. On September 22nd, 2021, the appellant, Mr. Michael Allen Serpas, acquired the property at 2101 June Drive, Nashville, Tennessee, 37214. The first page of the board's case summary is a list of 16 short-term rental hotline calls on the property with the date ranging from December the 31st of 2021 through May the 8th of 2023. The following pages are the individual printouts of the hotline calls summarized on the first page. Our department is almost 100% complaint-driven. I hope that this puts to rest any claim of harassment on our part. The next several pages are emails concerning the property between concerned neighbors, the district council member, and me. For several months, our investigation did not produce evidence to legally prove the accusations. We suspected that the appellant resided in Chicago, Illinois, but were unable to find enough legal documentation to substantiate that. On March 16th of 2022, the appellant's authorized representative, Lanny Skidmore of the Lease Killers Property Management Company, submitted an application for an owner-occupied short-term rental property permit. On May the 4th of 2022, Inspector Robert Osborne processed the application. He determined that the application met all the requirements and issued the permit. On or about April 8th of 2023, I received a voicemail complaint stating that Mr. Serpas did not reside at 2101 June Drive. As a result, the case was reopened. This time, the investigation yielded a considerable amount of evidence. Mr. Serpas' LinkedIn account listed him as a founding partner of Old Town Capital Partners in the greater Chicago area. Old Town Capital Partners website described the company as follows, and I quote, "A real estate investment and development company focused on South Florida multifamily development and Sun Belt short-term rental home acquisitions." The appellant's bio on the Old Town Capital Partners website opening reads as follows. Michael is a founding partner of Old Town Capital Partners. Mr. Serpas oversees the company's income arm, specifically the workforce, housing, and short-term rental portfolios. Mr. Serpas' Instagram page reads Michael Serpas, Miami. Properties, at 2101 June Drive, the short-term rental application and deed of trust are signed by Mr. Surpas, and the address given is 35 East Division Street, apartment 3A, Chicago, Illinois. Michael Allen Surpas, 2101 June Drive, August, short-term rental board meeting. No vehicle registration to Mr. Surpas in Davidson County. There are several companies that are owned by Mr. Surpas in the form of LLCs. The Arizona company, 7303 East Cypress Street, LLC goes to 35 East Division Street, apartment 3A, Chicago, Illinois. 6126 East Wilshire Drive, LLC goes to 35 East Division Street, apartment 3A, Chicago, Illinois. And 2902 North 81st PI, LLC goes to 35 East Division Street, apartment 3A, Chicago, Illinois. Florida companies, 1509 Northeast 123rd Street, LLC goes back to 35 East Division Street, apartment 3A, Chicago, Illinois. 6126 East Wilshire Boulevard, East Wilshire Drive, LLC goes to 35 East Division Street, apartment 3A, Chicago. Indiana companies, 920 South Logan Street, LLC goes back to 35 East Division Street, apartment 3A, Chicago, Illinois. 221 West Wayne Street, LLC goes back to 35 East Division Street, apartment 3A, Chicago, Illinois. Illinois companies, 3239 South May Street, LLC, manager Michael Surpas, 35 East Division Street, apartment 3A, Chicago, Illinois. Hotel and Capital Partners, LLC goes to 35 East Division Street, apartment 3A, Chicago, Illinois. Redwood Retail Holdings, LLC goes back to 35 East Division Street, apartment 3A, Chicago, Illinois. Hayes I or Hayes 1 LLC, agent Michael Surpas goes back to 35 East Division Street, apartment 3A, Chicago, Illinois. Tennessee properties, 6511 Robertson Avenue, 14 units at this property, all 14 units. Tax mailing address is 35 East Division Street, apartment 3A, Chicago, Illinois. Home inspection report for 6511 Robertson Avenue goes back to 35 East Division Street, apartment 3A, Chicago, Illinois. Short-term rental permit application for 6511 Robertson Avenue goes back to 35 East Division Street, apartment 3A, Chicago, Illinois. STRP sworn affidavit for 6511 Robertson Avenue goes back to 35 East Division Street, apartment 3A, Chicago, Illinois. Short-term rental property application contact address is Michael Surpas, 35 East Division Street, apartment 3A, Chicago, Illinois. Tennessee companies, each of these LLCs have not owner-occupied short-term rental permits for each unit named in the LLC name for a total of 14 short-term rental property units. The addresses for every unit is 35 East Division Street, apartment 3A, Chicago, Illinois, 60610. All 14 units were applied for after the 2101 June Drive permit was issued. In your case summary, following the documentation for each of these LLCs and the associated permits, you will find the information for 35 East Division Street, apartment 3A, Chicago, Illinois, 60610 from the official Chicago records and an interior photo of the condo from a real estate website. The zoning for the property in the surrounding area is DR-3, which is downtown residential multifamily, building not to exceed 3 stories. It is not commercial space. The properties in Tennessee, the Robertson Nashville 11 1213 LLC, address at 35 East Division Street, Apartment 3A, Chicago, Illinois. The Robertson Nashville 1-2 LLC, again 35 East Division Street, Apartment 3A, Chicago, Illinois. The Robertson Nashville 457 LLC, 35 East Division, Apartment 3A, Chicago, Illinois. The Robertson Nashville 3614 LLC, 35 East Division Street, Apartment 3A, Chicago, Illinois. The Robertson Nashville 8910 LLC, 35 East Division Street, Apartment 3A, Chicago, Illinois. The Robertson Nashville Holdings LLC, 35 East Division Street, Apartment 3A, Chicago, Illinois. The Robertson Nashville LLC, 35 East Division Street, Apartment 3A, Chicago, Illinois. Again, all of these permits were issued after the owner-occupied permit for 2101 June Drive was issued. I want to reiterate a closer examination of the short-term rental property permit application for 2101 June Drive uncovered a previously discussed deed of trust that declared that the borrower, owner, the appellant, or any associate did not currently occupy the property nor had any intention to do so. The borrower owner's address listed on the deed was 35 East Division Street, Apartment 3A, Chicago, Illinois, 60610. And again, this is the deed of trust for 2101 June Drive. Mr. Surpas's representative signed an affidavit that all of the information submitted in the short-term rental property permit application for 2101 June Drive was true and accurate. As admitted by the appellant's attorney, Mr. Klein, the appellant rented a condo at 690 Southwest First Court, PHI 11, Miami, Florida, 33130 for the period of July 15th, 2022 through July 14th, 2023. As previously noted on his company website, that is where his business is located. I included only the signed pages of the Miami lease in the summary. I do have the entire lease for your perusal if you need it. The Davidson County Clerk does not have a vehicle registered at 2101 June Drive or at any other address in Davidson County for Mr. Surpas, and he is not registered to vote in Tennessee. However, he is registered to vote in the state of Illinois. On May the 10th of 2023, the revocation letter was sent with the effective date of May 24th, 2023, as law requires 15 days before the revocation goes into effect. On May the 25th of 2023, Inspector John Phelps posted a stop work order and a copy of the revocation letter at the property, 2101 June Drive. Inspector Phelps made several trips to the property in the evening and found no sign of anyone living at the property as visible from the street. The photo evidence of the visits is at the end of the case summary. The Codes Department received one letter in opposition, which is included. Another opposition email was received, of which a hard copy has been provided to each of the members of the board. The following 4 pages are excerpts from the deed of trust assignment and leases and rents, a security agreement, and a fixture filing for 2101 June Drive, Nashville, Tennessee, 37214. The first page, document, page 1, is deed of trust. Second page, document 5, 2101 June Drive, Nashville, Tennessee, is listed as the address for the deed. Third page, document, page 25, is a non-uniform covenant quoted below. Non-uniform covenants, number 4, borrower or lender future covenant and agrees as follows. 4.5, use of property. Borrower will not at no time during the term of the loan inhabit the property. The property is owned and held by the borrower as an investment property. None of the borrower or any owner, employee, or other affiliate of the borrower now occupies or uses the property, and none of them has any present intention to occupy or use the property in the future as the principal residence or second home of any borrower or any owner, employee, or other affiliate of the borrower. Each of the borrower and its owners, employees, and other affiliates now occupies and uses other property or other properties as such person's principal office, residence, and/or second home.
Okay. Thank you, Mr. McBroom. Does anyone have any questions for Metro before we hear from the appellant? I'm going to take that as a no. No one has any questions? Okay. Okay. Let's review the rules, right? We've got opposition to this case, so there's going to be 10 minutes total. Alicia's got her handy-dandy timer going over there. Am I right? Cool. So any time that you want to reserve for rebuttal, great. You're not required to. And folks, when we get to the opposition, please work, as you saw with the last case, work out amongst yourselves who's going to speak. And if it's all of you, just be very cognizant of the time, okay? Great. Okay. And name and address for the record, both of you.
Thank you, Board Member Ryan. My name is Seth Klein. My address is 1015 Fatherland Street, Unit 205, Nashville, Tennessee, 37206. As a matter of procedure, I have two preliminary petitions and/or requests for the board that I would request not count against my 10-minute timeline, if I may proceed.
I don't believe we're going to do that.
Ma'am, I have the right to request that pursuant to the Rules of Administrative Procedure, Rule number 7 and subsection H3.
I believe you do have the right to ask, and I believe I do have the right to say that we're not going to do that, right? We're not going to suspend the rules. I'm going to defer to counsel here.
We're operating under your rules of procedure for this board.
Yeah.
If maybe I could paint some color as to my request.
You've got 10 minutes, counselor, to do with what you will. So knock yourself out.
With that case, I'd like to request 3 minutes for rebuttal. Please, Board
So
Member
you'll
Ryan.
have 7 minutes up front to speak and 3 minutes for rebuttal, because we're going to have 10 minutes for opposition and 10 minutes for your case.
Thank you, Board Member. To briefly
I'm the
address...
chairman.
I'm
You can
sorry.
address me as chairwoman or chairman. That's great. Please
Yes,
go ahead.
ma'am. To briefly recap the facts of this matter, Mr. Serpos did purchase the property on May 4th, 2022, and obtained a short-term rental permit for that property. It was timely renewed in 2023. There have not been 3 violations of generally applicable provisions of the Metro Code of Laws. There has not been a cessation of operation of the property for 30 continuous months and/or failure to renew the permit. Given the abbreviated amount of time, I would like to take this time to pass these documents to you if I could have some assistance and/or if I could approach the board. Thank you, Mac. 3, 6, so let's see, 1, 2, 3, 4, 5, 6, there you go.
Thank you.
So I have my exhibits labeled with tabs that way to make this a little bit more efficient for everyone to address. So specifically, I'm going to address a few points in Mr. McBroom's write-up and go from there. So specifically, a few things. Mr. Serpos does not own a vehicle. Therefore, there is no reason for Mr. Serpos to have a vehicle titled in Davidson County, Tennessee. He does have a rental car that he rents when he is in town. Mr. Serpos travels for work more times than not. This is his primary function is real estate in multiple markets within the country. And and therefore he is traveling quite often. And although not at the residence often, this is quite literally the only residence that he owns in the United States of America. There's no other property, no other lease. There is no other documentation or support otherwise to state that he lives anywhere else. So I'd like to address that first and foremost. Secondly, with regard to the deed of trust, as has been notated in the prior hearing, this board's review is curtailed to whether or not the question presented is whether Mr. Serpals resides here as his primary residence. Whether or not Mr. Serpals may or may not be allegedly residing in a property that his mortgage company thinks is an investment property is not within the scope of the decisions within this board, in my opinion. However, I do think it carries weight. I do not think that is the decision for the board. The decision for the board is that the information presented is proof pursuant to the Metropolitan Code of Laws as to whether or not this is Mr. Serpals' primary residence. So with that, I will direct you to Exhibit 9, Collective Exhibit 9. As you will see, Mr. Serpals, his driver's license is listed as 2101 June Drive, Nashville, Tennessee. That driver's license was issued on October 21st, 2021. You will see that Mr. Serpals' bank statements are listed as 2021 June Drive. You will see that Mr. Serpals' warranty deed for the property lists the new owner address as 2101 June Drive. There's a copy of the 2021 tax returns from Mr. Serpals, which list his address as 2101 June Drive. Which is above and beyond the requirements pursuant to the Metropolitan short-term rental website for proving residence for an owner-occupied permit. Nonetheless, I do draw near to the fact that there were quite a few LLCs that were created that listed the Illinois address. I will now direct you to tab 5, which shows that all of these addresses, as far as principal mailing address and mailing address for these entities, have been updated and corrected. I will admittedly say that these LLCs were created by Collins Legal with the information that was in our client record database at the time. We did not have Mr. Serpals' updated email address. This was an oversight on our part. However, since noticing this or being notified of this from the public records request that we submitted through Hub Nashville, I realized of this mistake and have since corrected all Tennessee entities. Also, in the background and simultaneously with this, though have not been completed, Mr. Serpals' attorneys and or agents through Old Town Capital are correcting the addresses for those entities that are outside of the state of Tennessee that fell outside of my purview. Therefore, I did not complete that work prior to this hearing. A few other things that are important to note with regard to this property. Mr. Serpals has been in communication with Metro Code since purchasing this property in order to be in compliance, and did initially start renting this property as a long-term rental. Those emails are contained in Exhibit 6. And those emails are dated January 5th, 2022, to show that Mr. Serpals was doing everything he can to comply. He, in fact, said on January 6, 2022, I'm applying for an owner-occupied permit. I've already become a Tennessee resident and have a Tennessee driver's license. My Chicago lease expires in March. I will be moving to the house. In the meantime, I plan to find renters for 1 to 3 months to help offset my living expenses. Clifford, the tenant you might have met, is staying in the property for 30 nights. Mr. Serpals at all times has done everything he can to comply with the short-term rental laws with regard to advertising and operation. The question again becomes whether or not this is his primary residence. Given the fact that Mr. Serpals quite literally does not own any other property in the entire United States, or for that matter, the world, this is by definition, given that his lease in Miami, which I proffered to be completely candid and transparent with this board, that he was staying there while renovations were being completed. The whole copy of the lease is attached as Exhibit 8. This is his only property. This is his primary residence. This is his domicile. This is where he intends to remain indefinitely and return back to. The short-term rental code, the Metropolitan Code of Laws, the definition for a permanent residence is not there. Therefore, we default to the Tennessee rules, and with that, I would say in accordance with also the checklist for owner-occupied permits.
Thank you so much, Counselor. Your time's up. Thanks so much. Greatly appreciate all the information.
Thanks, Mac. I appreciate it.
Okay, why don't we, as we did with the last case, have you folks step aside, and we'll allow the opponents to come forward. Goodness. Now, again, folks, the time. Okay, super.
Yeah, all right. All right.
Okay. So very much like the last hearing that I know you all were in attendance for, we greatly appreciate you coming here today and sharing your time with us. Let's try to keep the comments as much to the issues at hand as possible. Not the global issue of whether or not you approve of short-term rentals, but rather this case in particular and this gentleman who purports to be your neighbor, okay? And what's happening on your street and with this case, okay? Sound good? Great.
Thank you, Madam Chair. My name's Alan Gebhardt. I live at 2008 June Drive, which places me diagonally from the property at 2101. Every time you drive out of my driveway, you're facing directly toward that house in the driveway. Just quickly to show you what we feel about our neighborhood, my family moved in this house in 1955. My mother lived there 63 years, and I was thrilled to move back in, be able to buy it when she passed away. So we love the neighborhood. It's a very nice neighborhood, and this has made a big difference in it. We are very active in our life. We go in and out the driveway a lot. We walk. We always look at the house, and there is no indication that anyone has lived there. For at least 6 weeks, there were plumbing trucks in the driveway regularly almost every day, so I don't think it could be occupied. I heard the date of when the permit was expired, was rejected, and there have been cars there without a state tag since then, including this weekend. So whether or not it's operating, I can't tell you. The reason, what I see is that tells me it's not occupied is that trash cans are put on the street and sit there sometimes days before they're emptied and days after. Packages arrive on the front porch and they sit there forever and ever. No indication at all that anyone lives there. There haven't been a lot of problems with the tenants, except one night I couldn't get in my driveway because whoever was renting it had so many cars and so much company that couldn't get in. They parked everywhere. So I would ask that the board take serious consideration, reject this permit, not only the early application, but reject the permit in total. We see no indication that anyone lives there. Thank you very much.
Hi.
Thank you, sir.
My name is John Zapian-Pina. I live at 2009 June Drive, which is directly next door. I first moved in November of 2021, and my wife was expecting. We actually met Michael because he was taking over the house, but really I've probably seen him maybe 7 times ever since then. For one reason or another. I did want to say that we do have the support of our District 15 Metro Council member, Jeff Syracuse, that this is not owner-occupied. And I've been there the whole time, and I can tell you it's just short term. It was long term for a few months in the beginning, and then it switched to short term, and it's just been people in and out all the time, and that's just the truth. He doesn't live there, so.
Hi, thank you for giving us this time and for the codes fellow that was handing out stuff. I'm Kim Parent. I live next door on the other side, 2105 June Drive, and I concur with all of this that's been said. It's a ghost house during the week. The lights are out. The garbage can stays out front. There's all different cleaning people that show up and walk out with big bags of cleaning material each week. And I'm also curious about the recent revocation of the permit, because they're definitely all through June and July busy people, Ubers, people standing out front smoking cigarettes, drinking beers, waiting for the Uber, loud parties. I have a recording of a loud party of people drunk. My husband said it feels like we're living next to a fraternity now, and it's been especially noticeable this summer. And what was the other thing? I had something else. I don't want to use up too much time. Anyway, I don't believe anybody lives there permanently. I mean, it's kind of laughable. So that's all I got.
My name is Aaron Williams. I live at 2128 June Drive. I've lived there since the early 60s. And when I purchased my home, I thought, this is going to be my home forever until I die. I can't imagine now thinking there's going to be a commercial situation on June Drive. It will destroy the neighborhood. Now you say, okay, well, what about just renting the property? That would be fine. I would have no problem with that at all. But we're talking about a profit-making situation. Each weekend, somebody different. Traffic. It just blows my mind that we have a phantom residence on June Drive, but they still want to make it as a property where they can rent it on weekends. That's all I can think about. I'm sorry.
Thank you, sir.
Good afternoon. My name is John Spangler. I live at 2137 June Drive. I'll be quick. I just want to go ahead and state as just another point of fact, I have a 1-year-old and a midwife, and I'm a musician, which means that I don't sleep ever. And so I am traveling past the house with a 1-year-old or with my wife at random hours of time, and I've gotten to wave to a lot of people with a lot of cars at that house at different times of the night and different times of the day, but I've never one time ever seen Mr. the appellate in that place when I've waved to someone. It's never been the same person twice. It's always a new person, if the house has anyone staying in it or not. And so I just want to go ahead and kind of clarify from my viewpoint. You already have seen, obviously, his socials and things like that, so I don't need to reiterate that his own company website specifically states he deals in short-term rental, and so I understand we don't deal in coincidences, but we do deal in primary residence in that definition, and so we have a lot of people here today supporting the fact that when we do see someone there, whether it's 4 or 5 cars packing the place, they're never the same person because it's clearly being used as a short-term rental, and it's never being used as a primary residence 0 times out of 365 days of the year. Thanks.
My name is Linda Spear Gebhardt. I live at 2008 June Drive, which is diagonally, as my husband said, across. I am out sometimes late hours of the night. I work at the local theater in town, and there is no one that lives in that house on a permanent basis. The house is vacant, the garbage cans sit out front, and it has been rented. If they had a stop order in May, it's been rented since then. There are some cars there this past weekend. So again, to state the problem at hand, there is no one that lives permanently in that house.
My name is Samantha Zapian Pina. I reside at 2009 June Drive, and I'm a stay-at-home mom, so I'm home all day, and I can say that I've never seen the appellant at the house, at least to my knowledge. I've not seen him maybe more than twice in the few years since he had bought the property. My biggest complaint is the noise at night. My daughter's nursery faces directly to their driveway, so I do find it to be very disturbing. But I guess that's all.
Thank you very much, ma'am. Okay, so you folks still had 2 minutes left. If there was anything further you wanted to add, you're welcome to, and if not, there's really no need to revisit the same issues. Go for it.
I just had one question. Can you be a permanent resident of Tennessee and vote in Illinois? Can you be registered to vote?
I think that's outside of my scope of knowledge. I suspect the answer is no, but that's a great question that we'll leave out there in the ether. Okay. Folks, thank you so much for your time. We greatly appreciate it. The appellant and his learned counsel have, what did we say, 2 minutes? 3 minutes for rebuttal. Very good.
Hello, my name is Michael Serpos. I reside at 2101 June Drive in Nashville, Tennessee. First off, I'd like to apologize for the recent noise. My parents, my brother, his wife, his kids have been here visiting me for the past few days, and so we've been in the pool, we've been hanging out. I apologize for that. You can come have a drink with us later. The facts of the matter that have been presented are all accurate. I am self-employed with a business partner through Old Town Capital. We are real estate investors. Our primary place of business is Miami, where he lives. I do not. I formerly lived in Chicago. My agency and cogency, which was attached to my previous apartment / place of business, clearly is outdated. I apologize for that, but that's just created some clerical issues on my part, which we've reconciled. I bought this house in September 2021. The intent was to be a non-owner occupied long-term rental. That was what the mortgage was for. However, and we started doing that, and I had good tenants and everything was in compliant. I wanted to move in after my lease expired, and that was the intent. So in the spring of 2022, I got a Tennessee driver's license. I moved into the home, and clearly I travel often for work. We have holdings in South Florida, Tennessee, Chicago, Indiana, Austin, Scottsdale. I am on the road all the time, which is not a crime, nor do I believe it bars me from getting this permit. I resided there last summer, clearly in and out, until I did remodeling, which started in December and lasted until April. I was not there during that time. I stayed in Miami for the bulk of that through a lease throughout this entire time. My driver's license did not change. I never claimed to be a South Florida resident. My lease has expired. It expired this summer, and I have moved back in, albeit still on the road. I don't think I've been in the same city more than twice the last 3 months. Again, I apologize for that. This intent was never to create confusion or to game the system. It's simply, I live an active life. I work remotely. I manage a lot of businesses, and I want to set my roots down in Nashville. So I want to say that. If you have ever any issues, please, my direct line is always open, as is our management company, who I believe has a pretty good reputation here. So thank you.
And lastly, with my time board, and thank you for hearing our argument, is that I will restate that pursuant to the guidelines to prove residency for an owner-occupied permit, Mr. Serpos submitted more than what was required, and also attached in this petition. Mr. Serpos, again, does not own a car. Therefore, it would be reasonable for there not to be a lot of car traffic in and out, and also to look like a transient tenant coming in and out via Uber. So while I do understand the arguments from the opposition, again, we are here to determine whether or not the burden of proof has been met to prove residency for an owner-occupied permit. Thank you.
Thank you. All right. Does anyone have any questions for either side or for Metro? I do have one for Mac, actually. Do I remember that there were, I do remember there were complaints against the unit, right? There were
Numerous.
How many?
Off the top of my head, at least 16. They're all outlined in your package.
Can you just tell me what page? Because I think it's like 80 pages.
Give me one moment. I'll pull it up on your screen.
Anyone have any other questions?
Do you want to wait on that? Or
go ahead. There we go. Thank you. And what page is that? It's 14? Very good. Thank you. Yeah.
It's 14, and it probably runs through about 30.
Awesome. Super. Thank you. That's all I needed. Whitney, go right ahead.
Mr. Serpas, how many companies do you have an ownership interest in?
Estimate 20.
Okay, so how many K-1 statements do you get each year?
A handful. Many of those were formed in the last 12 months or 18 months, so you wouldn't have possession of them, but a handful.
Okay. Mr. Khan, you provided us with the 2021 K-1 for Blue Whale Capital.
Correct.
What's Blue Whale Capital?
An investment club with about 12 members based in Minneapolis.
Okay. Mr. Klein, I presume that you don't have 2022 taxes?
I have not filed them yet. They will be filed with my residency being Tennessee.
Okay. What's the last election you voted in?
It's been a few years. 2020. I voted in Illinois.
Okay. Matt, do we have documented stays for the property?
Oh yes, ma'am. You have to realize that the permit was issued, so there are numerous stays.
I'd like to cross-reference, if we can, the documented stays for, I'd like to know your time period for renovations on the property, and I'd like to cross-reference the two.
Yeah, it was roughly December to March or April. I believe the impetus for this entire situation was a noise complaint stemming from construction outside of my control. I received a stop work order from it, but that is...
October 2022 to April 2022?
No, December 2022 to April-ish 2023. There would not have been any stays during that time period, and I was in and out. The home was uninhabitable. I can show you pictures of a brand new kitchen.
I'm just asking Metro to tell me, or do we have documented stays during that time period?
I'll have to see if I can pull that record up.
Okay.
Yeah.
If nobody has any more questions for the appellant, I'm going to close the public hearing. Or we want to wait till Mac has found what he's looking for?
No, I would prefer to wait because I can unequivocally say there was no stays.
And I apologize. What were the dates we were looking for again, please?
Late December 2022 through roughly April 2023. There was a very cold period and it burst a pipe, and I used that as an opportunity to remodel a house.
Do you see what appears on your screen?
Mm-hmm.
Yes.
To December. 3 April.
Yeah.
December 22, April 23.
Very good. Okay. Do you have what you need, Whitney? Okay. We are going to consider the public hearing closed. Gentlemen, thank you so much for your time and all the information.
Thank you.
And we're not going to hear from anyone else unless we reopen the public hearing and ask a question of you. So no volunteering of information as we have our discussions. Thank you very much. Okay. Anyone like to start?
I'm just a little flabbergasted. It's it is sort of beyond my ability to comprehend that signing a legal instrument through which title would be transferred to a property wherein you represent that you are only an investor and do not intend to occupy the property would be of no legal significance or effect in this proceeding where we're trying to determine whether or not you were an owner or an occupier of the property during the time period under consideration. That's pretty dispositive to me.
Okay.
I don't know that I need to look much further than that.
Okay.
That's where I'm sitting.
Okay. Anyone else?
I think that this is one of the most well-attended hearings that we've had. I appreciate Mr. Klein's comments that there are guidelines to establish residency, and yes, those guidelines are very clear. But having guidelines doesn't negate the opportunity for there to be evidence and rebuttal that is or is not the case.
Right.
We have seen this before, and I think we've had this very conversation, and perhaps maybe even with this very representative, that when you own the house, of course you can get the driver's license. When you own the house, of course you can get an address on your bank statement to say that. That's standard. Of course you can get those things. That is not the end-all and be-all, right, of evidence. And I think it's telling that we had such a robust attendance today by the neighbors who are in a better position to know.
And their testimony is directly relevant in this case. You know, what they're seeing and what they're observing is pertinent.
Well, I think, too, and we need to go back to the basics, which is we're governed on this matter by the same ordinance, which is a very simple ask of us. This is not a particularly heavy lift. The question is, do we believe the zoning administrator erred? And that's the only question before us. Judging by what we've seen, do we think the zoning administrator erred?
If I were the zoning administrator looking at the evidence that I saw, particularly the section or paragraph 4.5 of deed of trust, there would be no question in my mind.
I agree. Well, then let's make a motion that we are, I move that the zoning administrator did not err in this case, and we will not be offering any relief to this appellant at this time.
Second.
Do I see a show of hands? Very good. Gentlemen, thank you so much for your time today, but we're not going to be offering any relief in this case.
Do we need to return these?
Mr. Klein? Thanks for coming, folks. We greatly appreciate it. Nobody wanted to stay for board business? Terrence, we still have we're still in a hearing. Okay.
I'm sorry.
That's quite all right. I know you didn't know, but we still have a hearing going on because we have rules that we have to review.
Correct.
Sorry about that. You boys can have a drink later.
Listen, I'm trying to stay out of the doghouse today.
Okay, so moving on to the next matter at hand. We have, let me look at my phone because I have the notes on this. We have to vote on some things. We are supposed to have elections in May, and we didn't have a meeting in May. And then we had a very small group, I think, in June or July. Maybe we were canceled in June. We had a small group in July, and we voted to delay them into August. And it's August. So now we have to have elections. So the question before us is, is anyone interested in being nominated for chair? It's so much fun.
I think you're doing a bang-up job.
And I'm making nomination.
I was about to say, may I also make it? Yes.
I am happy to continue to serve. I'm also happy to pass the gavel
Well,
along
that is-
to any interested party.
I think you're doing a masterful
Well,
job.
I couldn't do
so.
it without you, Terrence, so I'm going to make a motion that Terrence continue, too, as vice chair.
So we need to probably clean that motion up.
Yeah, we're going to clean the motion. We are. I just want to make sure we're all on the same page.
Okay, so how about you call for nominations for the chair?
Okay.
Do you gather all those nominations, have your vote, yay or nay, and then
we'll-
gather nominations for the vice chair, and then have that vote?
Shall we gather nominations for the chair?
I nominate Julie for the chair.
I knew I wasn't getting out of this one. Yeah.
You were not.
I graciously accept your nomination.
Thank you.
Shall we have a vote?
A vote, yes.
Mm-hmm.
So
I don't think I'm going to move to vote.
I move that we reappoint Julie Caputo as chair.
Second.
Okay.
In favor.
What the hell? Can't beat them, join them. Okay, great. And I move that we renominate and re-elect Terrence Bond as the vice chair.
Seconded.
Excellent. Shall I see a show of hands? Excellent. This was so easy. Is there anything else that we need to deal with?
No, you're all done.
Oh, fantastic.
I just need to ask, since I was not in attendance at the last meeting, was there a vote taken on the approval of the rules of procedure? We had typographical errors that had to be corrected.
No, we do need
I don't think we did do that.
to take that up.
That's a good question.
We didn't do it.
Okay.
Well, I would just like to point out that these rules were voted upon previously. We found various typographical errors and decided that it would be necessary to vote again. I would like to point out that in number 5D, the word member was supposed to be members. It is now members. In Rule 7B, number 3, the word at was added. 7C, the word be was added. And that covers everything that was changed, and that's what needs to be voted upon.
Okay, but Mac, it's not on the agenda, so they can't vote on it. You need to have it on the agenda.
Oh.
Because there has to be notice of that.
Boy.
I know.
We're really dragging out
I'm
approving
sorry.
these 3 words, aren't
Just
we?
make sure that next month it's on the agenda.
I would also like to ask that once we add it to the agenda, that we have those 3 points to look at with the copy of the rules so that we can make
Right.
a fully informed vote.
You want a red line version. And I believe they did circulate that previously.
My apologies.
But
if I
they
missed
can
it.
recirculate it for
Okay,
the next meeting and put it on the agenda.
Now, we do have on the agenda the public comment. Was that covered last time?
That's not something they need to approve or not having on the agenda. That's just something that's required under state law now.
To be
That's why.
need to be read into the record?
It doesn't have to be read into the record. It just needs to be on the agenda. It's required that the agenda give notice of the form in which public comment can be given. And that's why that verbiage is added.
Got it.
Yes. That's a law that took effect in July 1st.
Got it. Okay. So we have all taken note that for next month's agenda, assuming we have a meeting next month, do we have cases for next month? How many? Oh, we can handle that. Yeah, let's make sure that we add that, tidying up those rules to the agenda, and we will deal with it then. Because we'll all be back.
And thank you for keeping us honest.
Thank you, Ann. Yeah, we greatly appreciate your guidance, and Mac and Alicia, everybody. Okay, shall we consider today's hearing of the Short-Term Rental Appeals Board closed?
Yep.
Awesome. Thanks.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.